Hi, my name is Cindy Gallardo. I want to tell you a little bit about Vincent Davis and his associates and how they've helped me in my situation. I was made false allegations by my daughter. A couple days later, CPS came and took my kids. My husband and I went to Mr. Davis's office. Again, the reassurance and just calming us down, letting us know that everything was okay and just telling us what our next Mr. Davis has given his personal number to contact him, and he gets back to you right away. There's no other attorney that I feel has done that.
Welcome. Good morning to CPS Office Hours. I am Attorney Vince Davis. Today's live stream is serious. If you've been accused of physically abusing your child, or if someone made that allegation against you, you're facing one of the most severe charges in the CPS system. CPS can remove your child, terminate your rights, and place your name in the Child Abuse Index, all based on allegations that may be false, exaggerated, or misunderstood. Today, I'm going to walk you through what to expect, how CPS defines physical abuse, why they act so quickly, and most importantly, how to fight back at every stage of the dependency process. If you're facing this right now, call me immediately. Let's build your defense before it's too late. Part 1. What is physical abuse under California law? The legal definition is found in California Welfare and Institutions Code section 300A. Quote, the child has suffered, or there is a substantial risk that the child will suffer, serious physical harm inflicted non-accidentally upon the child by the child's parent or guardian. Now, this includes bruises, burns, broken bones, or other visible injuries, evidence of excessive discipline, and allegations from the child, another caregiver, or a mandated reporter, such as a doctor, a school teacher, a therapist. One of the key points I want you to remember is CPS doesn't need a criminal conviction. Yes, you may be arrested for these allegations. Sometimes these cases are dropped by the criminal authorities. The DA doesn't file, the police don't arrest you. That doesn't mean CPS will drop the case. I get a lot of calls where they tell me, but the police dropped the case, or the DA didn't file, or I wasn't convicted. For CPS purposes, that doesn't matter. I know it doesn't sound logical, but that's the law. And the reason why that's the law is the burden of proof in a CPS case is much lower. It's a preponderance of evidence. In the criminal court, it's beyond a reasonable doubt. I don't know if you guys remember the case of O.J. Simpson versus, the people of California versus O.J. Simpson. O.J. went to trial in the criminal case and he was found not guilty because the standard of evidence was beyond a reasonable doubt. Very high standard. When I try to explain to people, I say, well, beyond a reasonable doubt is like maybe 95% or more that something is true. But a preponderance of evidence, well, that's more than 50%. So they took the same evidence in the OJ case, figuratively walked across the street, put on the same case, and I think OJ lost $42 million. So you see the difference. Same case, different results. Same thing in a CPS case. CPS case just needs the preponderance of evidence. Okay, part 2, CPS investigative stage. They will interview your child often without your knowledge. They'll go to school, they'll go to the daycare without telling you. Whether they can do that or not is a very gray area of the law. They will examine the child for injuries. They'll take photos, they'll look at doctor's reports. They'll talk to the teachers, the daycare, and the relatives. Most of the time, they will do this without your knowledge. What you should do: do not admit, explain, or justify anything. You will have the strong urge to do that. Say, "I'd like to speak to my attorney." Do not consent to a home search or safety plan without a legal review. If you'd like, call me immediately. My number is shown at the bottom right-hand corner. Part 3. The first thing that's going to happen is you're going to have a detention hearing. And here's some detention hearing strategies. CPS will ask the court to detain the child based upon risk of future abuse. Your job is to show immediate protective action and stability. Submit medical evaluations from independent doctors, counseling and therapy intake letters, letters of character from teachers, family, clergy, custody agreements if applicable. And if the judge decides to temporarily detain your child, make sure you and your attorney request visitation, preferably unmonitored. But if the judge gives you monitored visitation, make sure that the judge orders that the social workers have the discretion to liberalize your visitation to unmonitored, and also to liberalize the frequency and duration of your visits. So I'll give you an example. A lot of judges in LA order 2x2. So that means 2 times a week, 2 hours each time. Or some judges go 3x3, 3 hours a week, 3 times a week. So, your attorney may go and ask for 5x5 or 5x4 or something like that. The code actually says that visitation should be as frequent as possible, given the nature and extent of your relationship with your child. Part 4, the jurisdiction hearing, where the fight really begins. This is the trial on the allegations. Don't skip it, don't miss it. Most judges will tell you at the detention hearing, if you miss this, you will lose automatically. So don't miss the jurisdiction hearing. This is the trial. You want to force CPS to prove the injuries, the causation, and the intent. You and your attorney must cross-examine the social worker. They're experts. If you don't cross-examine the social worker, if you don't testify, you will lose. I see a lot of trials where the attorneys show up and they argue. Remember, argument is not evidence. If the judge only has the social worker's report, you will lose. Key tactics: present alternative causes of injury, accident, medical condition. You can only present that by way of testimony, being sworn under oath, presenting witnesses. Your attorney cannot present it through his or her mouth. Present expert testimony, like a pediatrician, a forensic nurse, or a trauma specialist. Part 5, the disposition hearing, shaping the case. Oftentimes, the disposition hearing occurs with the jurisdiction hearing. So if the court sustains something regarding jurisdiction, it moves right into the disposition hearing. Propose your own case plan. For example, parenting classes, anger management, individual counseling. You want to make sure that prior to this, that you have already registered or started some of these classes. As I said earlier, getting into these classes early is not an admission of guilt. I repeat, not an admission of guilt. You want to show insight, emphasize learning, stability, and the willingness to participate in the plan. Remember, the disposition hearing is probably the most important hearing in the CPS process. The social worker has to prove clear and convincing evidence, not a preponderance, But clear and convincing evidence, two things. Two things. Number one, that you're a substantial danger, not a danger, not a risk, but a substantial danger to the child. Now, think about that. You have to be one bad MF to be a substantial danger to the child, no matter what you did. And if you're already counseling or therapy or anger management, it's hard for the social worker to prove you're a substantial danger by clear and convincing evidence. But even if they prove that, they have to prove a second thing. They have to prove by clear and convincing evidence that there's no less restrictive alternatives to foster care. Now, I can think of 101 less restrictive alternatives. A few months ago, one of the things that I presented to the judge, because she found that my client was a substantial danger to the child, I respectfully disagreed, but she found that the department didn't prove that there were less restrictive alternatives. And what I did was I brought in grandma, who said she'd move in with the family if the kids were given back to the mother. And the judge said, well, grandma can be an extra set of eyes. We don't have to take the kids and keep them in foster care. Give the kids back to mom while grandma stays there and watches. Yes, that was a less restrictive alternative. Now, it doesn't have to be grandma. It could be auntie. It could be a neighbor. It could be a friend. It could be cousin. That's just one of the less restrictive alternatives. Like I said, I can think of 101 less restrictive alternatives. All right. So if you want to get ideas, talk to your attorney. Give me a call. We can come up with 101 less restrictive alternatives. Part 6, failure to protect against non-offending parent. The definition of failure to protect in the Welfare and Institutions Code is found in Section 300B. It applies to the parent who knew or should have known abuse was occurring. What to do? Show no knowledge or access to the alleged abuse. Submit proof of separation, protection orders, or immediate cooperation. Enroll in a non-offending parent education or non-offending parent therapy. Yes, there is such a thing. Part 7. Review hearing strategy, the 6, 12, and 18-month strategies. Track compliance with every element of the case plan. File declarations and progress reports every 2 weeks before or every month with the social worker and 2 weeks before the hearings. Always request expanded visitation and reunification. Part 8, managing false allegations from the child or others. Children, depending on their age, may repeat things they were told, misremember things, or exaggerate under pressure. Mandatory reporters may overreact to children's statements. Did a child misremember? Did a child exaggerate? Was a child looking for attention? Or does your child have a tendency to exaggerate or even lie? Here's some tools. You might want to get a psychological evaluation of the child. The court can order that. You might want to get a trauma-informed child therapist. The court can order that. You might want to get conjoint counseling with a child. They call it parent-child interaction therapy. The court can order that. Part 9, preparing for the 366.26 hearing when it's almost too late. If CPS recommends termination of your parental rights, you want to always talk to your lawyer about filing a 388 petition showing significant changes. You want to present evidence of a bond and process. You want to ask the court by way of motion for a bonding study. That's a key point. You want to request legal guardianship instead of adoption. You're not out until the judge says your parental rights are terminated. And you're still not out because you can appeal. Part 10, post-termination remedies and civil rights. If your rights are terminated, you must file an appeal immediately. You might want to consider a federal lawsuit for civil rights violations that happened during the case. Was the removal unlawful? Were reports by the social worker falsified? Were you denied due process? If you think any of those apply, give me a call. CPS allegations of physical abuse are terrifying, but they are not unbeatable. Don't try to fight this alone. Don't wait until your rights are at risk. Give us a call. Book your consultation. Drop your questions today in the chat. I'll try to get to them and take some questions now. Let's fight. Let's win. I'm Ben Davis, and I'm here to help you. Okay, let's look at some of these questions. Oh, got a lot of questions today. All right, Betty Jo from YouTube. Good morning. Good morning, Betty Jo. Lorelei from YouTube. Good morning. Good morning, Lorelei. Deidre Payne. Deidre Payne says, "Yay! I finally am up early enough to catch you live, Mr. Davis. Good morning. It's Miss Deidre Payne, your number one YouTube fan and host for your platform. Everyone, Miss Payne is a host on. She has her own show on my YouTube channel. If any of you are interested in being a host and have your own show on my channel, drop us a note. Send it to our producer, Grace, Grace, at vincentwdavis.com. Dorothy from Facebook says, question, can CPS record be expunged? You know, that's an interesting question. Expunged, no, but it drops off after, I think, 10 years. And before they put you on the Child Abuse Index, you're entitled to have a hearing. Now, whether you win that hearing or not is a whole nother question. It gets kind of complicated. So, Dorothy, if you have a specific fact pattern and you want to talk to me about it, give me a call. All right. Betty Jo. Betty Jo says, what happens if a child comes to a visit with bruises and scratches on them? Well, if I were the parent, I'd probably say, what happened? You know, this is not good. And depending on the age of the child, is the kid an 11 or 12-year-old who plays rough? Or is the kid a 1-year-old who doesn't play at all? All right. Dorothy from Facebook. Good morning. Good morning, Dorothy. Betty Jo. He has passed the caseworker or the supervisor advisor that's doing the visits where they're from, and they said that they don't know about the bruises. And then she goes on to say, what happens when you tell the caseworker and they don't do anything? You can report it to the hotline, Betty Jo. Every county has a hotline. And if they don't do anything, you can report it to the state Department of Social Services. And if they don't do anything, you can report it to the Department of Health and Human Services, which supervise all CPS all over the country. And you find them in Washington, D.C. They're the federal oversight of state and county CPS systems. Okay, from Facebook, a $5 super sticker from Deidre Payne. Thank you, Deidre. All right. From YouTube, Karmic Revenge. Betty Johnson, Stego County, New York. You can bring pics, have proof of your child being abused in the home that he was placed in, and the judge is going to just complain about how you were able to see or talk to. And then he goes on, that child. I'm not sure what he is trying to say, but if you bring in pics that you've taken with your camera, that might be evidence that you can show your child is being abused. And believe me, I've been involved in many cases where children have been abused in foster care. Many years ago, maybe 30 years ago, I represented a foster parent who was being prosecuted in an administrative hearing to lose her foster license. And she was charged with causing the death of a foster child. Now, I won't get into the details, but she lost her license. So things happen in foster homes, and we as a society place children in foster homes thinking that they're going to be safe, and it's not true. And as a matter of fact, I stopped doing that because I realized, a lot of times we take children from families and we put them in foster homes, and we think, oh, they're going to be all right, or they're going to be safe. It's not true. Sometimes we place children in foster homes, and we take them out of the frying pan and we just put them in the fire. Um, Foster parents are just people, just like parents. All right. Betty Joe from from YouTube. So what happens when the child is crying, when you leave the visitation and your wife and tears away, and you tell the caseworker she's crying and she tells you to stop lying? Betty Joe, what you don't do is get in an argument with the social worker. If the social worker doesn't have the empathy that you expect, don't react, because if you do, they're going to try to use it against you, and they will certainly write it up, and they will tell a different story than what you actually experienced. Lorelei from YouTube, my attorney won't do anything. Would it help to file a complaint about my attorney? My appeal is coming up. Lorelei, that's hard to say. You know, every case is very specific. If your attorney is court appointed and you're in California, you should probably do a Marsden hearing and get a new court appointed attorney. Focus on moving forward, not moving backward. I have a video on my YouTube channel about a Marsden hearing, how to do it. So watch that video and get a new court appointed attorney. If it's a private attorney, go get a new private attorney. If you need help, give me a call. Okay, Carmen back on YouTube from New York. Workers in the school hospital don't even notify you they're going to talk to your kids. Right, they don't. I don't know what the law is in New York, but here in California, they don't have to, especially about suspected child abuse when you are the suspect. All right, from YouTube, Risen Rare Gem. Morning, Mr. Davis. Margaret from Utah. Good morning. I've been accused of everything. I had children taken away 2009, lost parental rights. Now CPS is after my third. CPS has been hurting me since 2016. Okay, Risen Rare Gem, let me tell you something. Why are you still in Utah? It's time to change states, change counties, something. If CPS is after you, it's time to make a change. From Utah. From YouTube, Deidre Payne. Yes, Deidre. Mr. Davis, question for you. Okay, what's the question, Deidre? Lorelai jumped in front of you, Deidre. Lorelai from YouTube says, I do not recall waiving my rights to a jury trial, etc. So I don't understand how we are here. Lorelai, I don't know what state you're in, but if you're in California, you're not entitled to a jury trial, unfortunately. And there are very few states that you have the right to a jury trial. Not too long ago, I was talking to someone in one of the states that you are entitled to have a jury trial. And I said, well, did you have your jury trial? And she told me no, that her court appointed attorney talked her out of having a jury trial. And I found that such an odd thing to say, because here we would give our right hand to have a jury trial. And there they're talking people out of having a jury trial. So it depends on what state you're in, Lorelei, and what your court appointed attorney has done on your case. Oh, Deidre, here's your question, I guess. At what age can a child request to be emancipated? And then, if the child can request that, does the child get to choose where they live? Well, the age it's different. It's a sliding scale, and it depends on the child. It depends on their maturity, their ability to care for themselves. Do they have a place to live? There's a lot of factors the judge has to look at. So there's no set age. If they're emancipated, they can live anywhere they want. But before they're emancipated, the judge is going to make sure that they have a place to live. Okay, Risen Rare Gem. Still have child with me. However, CPS is getting too close for comfort. Risen Rare Gem, I don't know what the facts and circumstances are, but maybe it's time for you to consult an attorney. Risen Rare Gem from YouTube, how can I get info from CPS if a case or cases exist without retaliation from CPS? You probably can't if they're retaliating against you. All right. Deidre Payne from YouTube says, Risen, just go to court and request a copy of the minutes from your last hearing. I did it myself a week ago. Oh, if you have a case, definitely. From YouTube, Lorelei Glatz. Good morning, Mr. Davis. Good morning, Lorelei. All righty. Having problems navigating these comments or these questions. Okay, here's a question on YouTube from Gina Dallas Diva. Question, can my daughter appeal if a psychological was not an original count, yet she took a psychological test that came back normal, yet the department forced her to take another one that is okay, not okay? Okay, Gina, I'm not sure of the question, but if the case is in California, she doesn't have to take a psychological unless the judge orders it. That's number one. Number two, if she took a psychological and it came back, and the worker wants her to take another one, I'd make sure that she and her attorney, she talks to her attorney to try to fight that. And I have heard, they go take a psychological test and they think you're crazy and it comes back normal. Then they want you to take another one. And that's no bueno, no good. Deidre says Wednesday at 5 p.m. Oh, this is Deidre's show. Deidre Payne has a show on Wednesdays at 5 p.m. Pacific Standard Time Are you a CPS victim like me? Everyone tune in to watch her show. Or you can watch the tapes. Deidre, still waiting on your guest appearance again, Mr. Davis, on my show. Okay, no problem. VJ from YouTube. Question, how can I get a copy of a tribal letter for Georgia tribe in Rhode Island to determine if my family is showing on their rolls? Good question, VJ. You're going to have to call the tribe. The tribe usually has a person who takes all those types of inquiries. And if you still have problems, you can call the BIA, the Bureau of Indian Affairs. It's a not a federal agency, but it's an agency that handle all types of inquiries about American Indian affairs. Okay, we're coming to the end of the show. I'm trying to take a couple more questions, but I do have to end early today. I am on my way to court for an 8:30 court appearance. Lorelei from YouTube, 3 times my son had been hospitalized after having to take drastic measures to get him seen. CPS kept denying him medical attention. How can I use this? Well, if the kid was in foster care and he had to been taken to the hospital 3 times, you might want to use that by saying to the judge, maybe he's not doing well in foster care and I can provide him better care in my home because that wasn't happening in my home. And later, if you want to file a lawsuit, civil rights lawsuit, maybe he's being injured or neglected in the foster home, right? All right. That's all the questions I can take today. I want to thank everyone for watching. We'll see everyone tomorrow on my office hours. Deidre, I hope to see you tomorrow morning on my office hours. Saturday morning, 6:30 a.m. Pacific time. Everyone stay safe. Have a good day.
I'm just so very thankful again to have them and to have found them, and I would recommend them to anybody that's going through this because it's hard and you're gonna make mistakes, and the mistakes can make the situation worse, but they come in and they just know what they're doing. And again, to have his number at your dispense, like no other attorney does that. And they get back to you right away and again comfort you, fight for you. They just reassure you and when you're going, like I said, going through this nightmare. And I'm so blessed to have found them.